question to you is that we have to look at the Constitution in totality as a whole. Does it not appear odd to you that for other crimes as big as perhaps treason in G and others, you can always come back and contest election? It's not a lifetime situation. But for a civil wrong, which could be as small as committing a misdemeanor of misdeclaration or just lying through you've omitted one entry in a return, the punishment in a way is for life. But if I were to go murder somebody, if I would commit treason, if I were to kidnapping, I could come back and contest election.
Where from the tribunal gets the powers for life time disqualification?
It has declared.
No, where from gets the powers to declare him
has
for
declared
life?
a decree given remains intact for all purposes. This argument basically it lies in Islamic principles. If you look at PPC, out of all those offences, there are very few offences in which mens rea is dishonesty. My submission is, wherever mens rea is dishonesty, we are talking about public office holder.
You just very casually referred to Islam. Either back it up because I completely disagree with you. You have to back it up. If your contention is agreed, there were those who were violently opposed to Islam, and then they became Khalifs, Khulfa Rashideen. तो वो आ ही नहीं सकते थे फिर वापस. This just don't throw in Islam just like that. It is contrary to Islamic injunctions. तौबा का प्रिंसिपल है, राय रास्त पे प्रिंसिपल वापस आने का प्रिंसिपल है, मुस्तकीम शारे मुस्तकीम पे वापस आने का प्रिंसिपल है. शुरू में तो 2-4 ही मुसलमान थे. तो ये आप ऐसे just don't throw in Islam to give it a validity.
No, my lord. What I am submitting is, if repentance or tawbah, when we look at it,
repentance और तौबा की तो बात से आगे मैं चला गया हूँ.
That's what I am submitting. These are 3 things kept by God to Himself. Number 1,
not at all.
Izzat Zillat.
Not at all.
Let me make my submission.
No submission. You refer to the Holy Quran. You can't just make a submissions contrary to Islamic principles like this. ऐसे नहीं होगा.
Could I change the subject a little? Let me just introduce one other aspect. Let's stay on 62(1)(f). If you look at 62, some of the disqualifications or qualifications are mentioned in the Constitution itself, like he has to be a citizen, the age and all. This is specifically provided. 62(1)(f) brings in a disqualification from a declaration from another court under some law, not the Constitution. It is a declaration of disqualification declaration of contrary under some law. And if the law, Parliament goes ahead and fixes that law and says any such declaration of that law has to be for 5 years, that is actually not tampering with the Constitution. It is providing that any declaration in 62(1)(f) is arising out of a law, not of the Constitution. Because court of law ne karni hai na disqualification. That disqualification is arising out of a law, and the Parliament goes ahead and says any disqualification under the law has to be for 5 years. So then, with that 5 years amendment brought in, isn't the period being provided for 62(1)(f)? Because the Constitution itself doesn't give an unlimited period. It is relying on a declaration coming out of a law. And law has been corrected and given a period. So there's a distinction. Had there been a constitutional provision, disqualification like age being 25, then perhaps, to my mind, legislation could not do it through ordinary legislation. Constitutional amendment was required. But in this case, the declaration emanates from the law itself. So law is being given a certain time frame. Is pe kuch roshni dal?
My lord, it depends on the validity of the law. That's why I tried to argue that under what proceedings we are before my lordships. I rely on PLD 2012 Supreme Court 923, Baz Muhammad Kakar Federation of Pakistan. It is the case where Contempt of Court Act 2012.
हमने सारा आर्गुमेंट सुना हुआ है, proposition बता देना please.
My proposition is through ordinary law, Parliament cannot amend the Constitution.
No, fair enough.
It has not amended the
That's what I'm trying to tell you.
Add it in the Constitution, because how do I demonstrate that?
Whether the court can amend the Constitution,
Court can interpret it.
interpret in a manner to amend the Constitution or to read into the
No, my
Constitution.
lord.
So this is what we are asking from you, whether the interpretation can be done. देखिए इसमें एक बात आप ये आप कह रहे हैं 62(1)(f) में ये बताया गया है कि डिक्लेरेशन होना चाहिए कोर्ट से, और आपने कहा कि डिक्लेरेशन सिर्फ ट्राइब्यूनल दे सकता है. ट्राइब्यूनल अंडर सेक्शन 157 वो ग्राउंड्स बताए गए, ठीक. क्या उन ग्राउंड्स में ये बात है कि ट्राइब्यूनल इस बात पे आपको डिस्क्वालीफाई कर सकता है कि आप राइटियस नहीं हो, आप जाइसे नहीं हो, आप अमीन नहीं हो, आप सादिक नहीं हो? ऐसी डिक्लेरेशन आएगी तो 162(1)(f)